Good afternoon, everyone, and welcome to our community conference call. I'm Rajiv S. Khanna for immigration.com, the law offices of Rajiv S. Khanna PC. We have this call every other Thursday, and we'll answer, first of all the questions that have been posted, then follow ups on those questions, then any new questions. Okay? Let me get started on answering the questions on the forum that have been posted. So the first one is from Katraj. He says, I've lost my I-140 original documents, both his and his wife's. His wife's I-140 was filed by the current employer. His was filed by the old employer. Priority date is not ported yet. How would it impact our green card process? Well, let me address these issues one by one. First of all, because the I-140 is really an application of your employer, it is not your application. You are not even required to have the original. Okay. Second, if you just need a copy, you can always file a Freedom of Information Act request / Privacy Act request. The forms are on USCIS website. It's a fairly easy thing to do. You can read up on it. Freedom of Information Act request / Privacy Act. You can always get copies of documents directly from the government. So you don't need the original. If you want a copy, you can always apply to the government. And the third thing is the priority date. The interesting thing is the priority date of I-140s is automatically ported. You really don't have to do anything. We do it just to be on the safe side and perhaps to reiterate to the government that's what we are trying to do. But technically, what the government does these days is they run scans. Oh, I forgot to turn my phone off. Give me 1 second. What they do is they run scans on their system and they automatically assign to you the earliest priority date to which you are entitled. So let's say you had a case approved in 2004 and then 2008 you filed a new I-140 through same employer or some other employer. They should automatically give you the 2004 date. Okay, so this is not something that I think should impact you. We plan to go to India next year, so just want to know regarding my daughter who's born here. Well, she's a US citizen, no question about that. Will she have the criteria to come back to US anytime? Yes, she has the power and the privilege to come back to US anytime, and there is no restriction. Do I need to report her stay anywhere in India? India, you might have to. You can check. I think it's a good idea to report to the US consulate. But people don't often do that, and I don't think it's the end of the world. So yeah, she is, of course, born a US citizen. Next question is Naveen 256 H4 and AP. I am on H1 extension and my wife is on H4. We both have EADs and APs. If she travels abroad and returns to the US on AP, does she revert to H4 after entering or revert to H4 while filing for the next extension? It's an interesting question. In my opinion, if she has not used the EAD, she will stay on H4 even if she enters on advanced parole. This has been the law, or at least the policy, for the last 10 years or so. I think the memorandum that addresses this particular issue came out in 2004. So that memo is still good law. It's called the Cronin Memorandum. So if she enters and she has not used her EAD ever, she comes back on H4. But if she has used her EAD or she enters and starts using her EAD, she is no longer on H4, but she can revert to H4 by re-entering US, say on H4 visa. Okay, and her working on EAD does not affect your H1. You can continue working on H1. So, and even if she works on EAD, it does not affect you. Okay. Next question is from Samir, who's ImGen Help 2014. Green card to citizenship questions. I am an Indian national married to a green card holder. I-130 has been approved. Spouse got his green card through family-based immigration 5 years back in May 2008. The rules for getting the green card, actually you mean naturalization. Rules for getting naturalization or citizenship say 30 months stay in the US and more than 5 years of getting the permanent residence. More or less correct, a little bit off, but let's go with that. Okay. So then, unfortunately, she has made, it's a she or a he because the first paragraph said he. Okay. Unfortunately, she or he has made more than 2 trips, each comprising more than 6 months, due to her education. You see, that's a good reason. So if the trip is less than a year, more than 6 months, and there's a good explanation for it, it should not be a problem for naturalization. Okay, and you have all the evidence. I think you'll be fine. Let her apply for her naturalization. I don't see any problem with it. Okay, good luck, Samir. Next question is from Rina Iyer. Consular processing for my father. I became a US citizen a couple of months ago. I want to process green card for my father, who's currently here on a tourist visa. Can I do consular processing? Well, I have a video on this where I told people, if your family member comes into the United States and you try to change their status, what is called adjustment of status, within the United States, government can take the position that this is fraudulent. You entered USA under a false pretense that you're going to go for a short period, and you had a preconceived intention of converting to green card. But let's say you come in and stay here for 2-3 months, and then your intention changes. That is perfectly acceptable. Okay, so listen to that video. It's in my blogs, and if something is not clear, we can talk about it further. In your case, applying an I-130 with the consular processing option is perfectly fine, because you're not asking for a change of status or adjustment of status. What you're saying is, my dad is here, he's on a tourist visa, he's not going to convert his status to green card. He will go back to India, I'm assuming this is from India, and he will then get his green card through consular processing. This is perfectly fine. Okay, and you understand that he'll have to travel back to India for the interview? Good, no problem here. Does being in the US when applying for a green card preclude him from consular processing? Not at all. Not at all. That is just fine. In the I-30 form, in the field date and place, guys, I cannot answer questions specifically about form filling, because if you look at every form, at the bottom of the form it will say whoever helped you fill this form should also sign the form. So I cannot help you fill the form, but I can tell you generically how things work. Okay, so if somebody is widowed or widowered, okay, and the question refers to present marriage or something like that, of course you can put not applicable, and this is not a major issue. I wouldn't worry too much about these issues, because the rest of the form makes quite clear that a person is widowed, or they have a currently existing spouse, or are they divorced. So there are other questions in the form that make these things quite clear. Then you asked me, I have one affidavit about marriage. Do I need a second affidavit? Always a good idea. Always a good idea. 2 affidavits is what the government wants. Okay. This question I think got repeated from Katraj. I've already answered this. Oh no, I think it's a little bit different question. H1 to H4, back to H1. I would like to know how to get converted from H1 to H4, then back to H1 after 5-6 months. What is the process involved? Is it safe or not? Reasonably safe. No more unsafe than any other process. Is it a cap issue? No, because cap only kicks in if you have been outside the United States for 1 year. So let's say I was on H1 for 1 year, then I converted to H4. 6 months later, or 8 months, or even 2 years later, I want to convert back to H1. I've lived here on H4. Am I subject to the cap? No. Why? Because I did not leave the United States physically for 1 year. Okay. So also, can I go to India after I get converted to H4 to get the H4 stamping and then come and convert to H1? Yes, absolutely. Whether you change status to H1 or you get a visa stamping and come back, it is the same law. No problem. Next question is Raji MG, priority date recapture. I'm in the process of filing the I-140 from employer B. Priority date from employer A for whom I do not work is November 2007. What documents do I need? I just said that a few minutes ago, that it should be automatic. You shouldn't even need any documents. Okay. Um, they should, USCIS should automatically do it for you. But if you have a copy of the I-140, of the old I-140, attach that, and that really helps. Number two, I have not left USA since 2004. I do have an H-1B visa stamped in my old expired passport. Can I go to Canada for stamping after the I-140 is approved? Definitely you can. Okay. One second. This is Kamalji from merasangeet.com. She's just sending me, anyway, I forgot to turn my, I forgot to turn off my internet messenger, so I'm going to have to edit that out. Anyhow, with that said, so can you go to Canada? Of course you can. I don't see any problem. Is it going to be a good case for Canada? If your degree can be verified, sure, you can go to Canada. But if your degree is from an institution that cannot be verified, for example, India, or you know, if you have a master's degree from USA or a bachelor's degree from USA, it's a fairly easy case. Or if you earlier have received a stamping from Canada, much easier. Or if your university has a database that is easily accessible, something like that. So the only time there can be a potential issue in Canada is if they cannot verify your degree. Okay. Can I predict the priority dates? I cannot. I have no idea. If my lawyer messes up my case, will you be willing to take my case? Sure, absolutely. This is not rocket science. Just law, guys. Next question is Rahul 1J, 11J. H-1B documentation for EC model. EC, I guess, would mean C for, I always get this confused. C for client, E for whatever. So you're working for, or end client consultant, something like that. Currently working for direct client B, employer is A, work site is client's location, and my direct supervisor is also an employee of A. So basically the employer has full control. So those are good cases to get stamped, Rahulji, but the problem is with consulates you never know what they are going to do. So what kind of evidence would you need, what you're asking me? I really cannot tell you. What kind of tricky questions can they ask? I cannot tell you. Does anything change in terms of 1, 2, 3 for H4 stamping? H4 stamping tends to be easier. Okay. So even people with the best possible H1 cases are getting delayed. I have a good friend, also a client, who is in India right now, and they are delaying him for no reason. He's a school teacher, very well established, has been here for years, everything is by the book. But you know, they are delaying him for no reason. For consultants, they have even bigger problems. So it's difficult to get visa stampings, no doubt about that. Then comes Ram 1973, but the writer is Swapna. Swapna says, green card holder in India for almost 3 years and want to return back to the US. I'm a US citizen. My mother got her green card through me by AOS when she was in US on a visitor's visa in 2009. She stayed for 7 months, but she has been out of US for almost 3 years now. She has a valid green card issued for 10 years. Applied for SB1 visa. So if somebody has been outside USA for a year or more, they apply for SB1 visa to try to recapture the green card because the green card is gone. Okay. So she tried it, but she didn't get it. She tried to get a tourist visa, she didn't get it. So questions, can my mother visit USA on her green card without returning resident permit? No. Airline will not issue her a ticket. Can my mother surrender the green card and apply for a visitor's visa? She can try. Very difficult to say whether she's going to get a tourist visa or not. If her visitor's visa gets rejected and green card surrendered, will I be able to apply for green card again? Absolutely. That is not a problem at all. So if I were you, what I would do, Swapna ji, is that try the tourist visa after surrendering the green card. That doesn't work, then just apply for a green card. Make sure that no misrepresentations are made during the process of the tourist visa application. Kumar 1216. If my employer applies for perm in my 4th year of H1B and due to bad luck it gets rejected in the 5th year, can I still continue to work after 6 years? You know, we've had cases like this where something like this happened. So what we do is we file an appeal against the denial to Board of Alien Labor Certification Appeals. Appeal typically stays pending for 3.5 years. And we time things like this, but once you have an appeal pending, you can still get H1 extensions beyond 6 years. So we time things in such a way, we start a new green card process, and when the timing is right, we withdraw the appeal and then file the new green card in such a way that your H1 does not get affected. So it can be juggled. It is not a problem. If my employer applies perm in my 5th year, what are my options? Well, tourist visa, student visa, working from India. Those are the 3 things. Or if your wife is on H1, you can go on H4. But there are no working options within the United States. People go on student visa, try to get CPT and work. In my view, that's a questionable option, because the government has been very concerned about so-called EAD factories, these universities that will give you an EAD or a CPT, curricular practical training, in your first semester. Government doesn't like that option very much. Okay, you gotta do it, but it's something I would avoid. But you can work for your company from India, your home country. If they can outsource the work to you, they can pay you on W2, 1099. They can check with their public accountant, certified public accountant, CPA, how this will be worked out. But I think that's an option. Your consulting company has 10,000 plus employees and a bench policy of 2 to 3 weeks. And in that time, but that's illegal, by the way. And in that time, if they don't find a project, they'll terminate my employment. And recently my project has ended. They're looking for a project. They've started the green card process, applying for perm in June. 6 years of H1 is coming to end in March 2016. Shall I stick with this company? I don't like the fact that they break the law. I mean, that's what bothers me, because benching employees is against the law. They have to pay you whether you have a project or not. Okay. So bothers me that they do work like that, and to me that's not a good sign. When a company breaks the law, it makes me wonder what they are doing. So I would avoid this company simply because I don't like the way they do business. Okay. Then comes, I guess the way this name is pronounced is Ficaret. Dear Mrs. Khanna, well, I'm not Mrs., I'm Mr. You can just call me Rajiv. I wrote about this topic December 9th conference call, and thank you for your answer. The reason I didn't write an email to me, and please don't put my email address on public forums, I wasn't sure if I did explain everything. My son's immigrant visa application was denied under 212A4 because you were not domiciled. Okay, so you got your green card in 2010, left, never established domicile, came back in September 2011, in between you were coming, and then in 2012 for 2 months. On January 2013, he did not get the visa. I live in USA since May 2013, except the month of September. I have a job since June 2013, an apartment since November 2013. So that means I started establishing the domicile on May or June when I started the job, or November when I got my apartment. Actually, interestingly, government would have accepted even if you showed them that you were about to domicile in the United States. So in this case, you're fine. You should resend the proof of domicile to the embassy, to the consulate, see how it works out. I think you have established domicile. Raj V, I'm on EAD from past 2 years, 45 is pending. Currently working as full-time for my green card sponsored company A having I-9. I got a part-time job in an unrelated field. Okay. Can I work on EAD for a full-time and a part-time? Absolutely. No problem at all. Two different I-9s? Yes. Does working for multiple jobs have any impact on my pending 485? It does not. Because you're still employed full-time at the sponsoring company. Is there a need to notify my current full-time employer? Nothing under immigration law requires that. But if you have signed a contract with them or if they have a policy, you may have to think about that. But immigration law does not require you to notify your employer that you're taking a second job. S. Ravs applied for change of status from H1B to H4. It's still pending. It's close to 180 days. So he left the country on 177th day. I-94 expired on October 3rd. See, I'm assuming that you applied for your change of status before your I-94 expired. If that is the case, you were never out of status and you were never unlawfully present during the time the H1B to H4 application was pending. Okay, I cannot help you fill forms, but you have not violated any terms and you have not been out of status or unlawfully present. Okay, when you have a timely filed change of status application, you are considered to be in something called authorized period of stay. So that's not illegal. I hope that helps. Does the consular office ask for the proof of H4 receipt? Normally no, but you should have a copy of the receipt anyway. I mean, that's not a big problem. So normally they don't ask for all that. J. Bhatti 25, I'm on B2 visa. My I-94 expired on November 4th, 2013. On November 2nd, I requested extension. As long as your extension request reached USCIS before November 4th, you're okay. My son will become a US citizen in 2 years. If I stay beyond the requested extension, will I be eligible to get a green card? The way it works, Mr. Bhatti, is this. Immediate relatives of US citizens, like parents, children, spouse, if they are unlawfully present in the United States even for 20 years, as long as they don't travel outside before getting their green card, they can get their green card within the United States. Okay, I hope that helps. Jay, okay, we've got 3 questions more left and then we'll start on follow-ups. Jay Bharat, 4 years and 6 months of experience before joining my current employer, and he wants to do a promotion so that he can go from EB3 to EB2 without changing jobs. Employer is giving full support, but their job says bachelor's degree or equivalent field experience. That is not EB2. If an employer creates a new position that requires bachelor's degree plus 5 years of experience, is that going to create any problem with the PERM application? No, no. Look, this is not something, Jay, that you should try to figure out yourself. Get yourselves a lawyer, a good lawyer. They will make sure, because these papers are filed under penalty of perjury. You can't make up things. Unless the case is properly prepared in good faith, you could get your employer into trouble, you could get yourself into trouble. But certainly the employer is free to create in good faith a job that requires a bachelor's degree. Okay. Monica, one of my colleagues, has posted for someone. Of course, you sent me an email, and since you've not disclosed your name, I will keep it confidential. I'm on the 9th year of H1B working for an IT consulting company over 100,000 or 100,000 employees. They're applying for H1B extension, which is H1B is expiring on May 18, 2014. Okay. Currently working on project A at client XYZ. This project is ending on May 23rd. They'll put me on bench and look for another project. My company gives about 5 weeks as bench period, illegal, and then terminates employees. For 5 of my co-workers who are working at the same client site, every one of them received an RFE. RFEs don't bother me. RFEs come as a routine in most cases anyway. USCIS wants to know about the client letter, and the company forwards screenshots of requisition that has details of job description, job title, client location. So the 4 questions below. Number 1, would you suggest that I ask my company employer to apply for my H1B extension in premium processing so that if there's an RFE, then I should be able to submit client letter while I'm on project? Look, this is a very dangerous situation. Under current thinking of the government, I'm dealing with 3 or 4 cases like this right now, where companies have been criminally indicted when they did not have a specific project. So I help these criminal defense attorneys who don't know as much in detail about immigration law as we do. So I help them deal with the government when companies are being prosecuted criminally. And not having a specific project and misrepresenting the project or the duration of the project is itself a ground for criminal prosecution. Okay. Second problem, if your project is only till May, you will get H1 only till May. So just keep that in mind. What happens if I'm on bench? You got a problem. Would you suggest that I apply for regular processing? I don't suggest you apply at all unless you have a project. How many days does USCIS typically give my company employer to respond to RFE on a client letter? I think it's 6 weeks normally. From what I remember. Burhan Arshad. Thanks for your help in getting my green card 5 years ago. Oh, you're one of our ex-clients. You didn't have to post. You could have just called us. Changed my address in June 2010, but as I'm filing for citizenship, I'm not sure if I informed USCIS about my latest address or not. First of all, file an AR11. Make sure you file it anyway. It can be done online. File an AR11. Make sure the government has your most recent address. Okay. Not having filed AR11 by itself should not be a problem. I mean, of course, government can make a sticky issue of it, but I would be very surprised if they do. So don't worry too much about this, Arshad. Go ahead and Burhan, go ahead and file your naturalization, but file an AR11 first. Okay. Well, we're done with all the questions that were posted. What I want you guys to do is only follow-up questions on what I have discussed. People who have a follow-up question, press *5 on your telephone. New questions wait. Follow-up questions, please press *5. 4 follow-up questions. 5. Okay. Well, after I deal with the follow-up questions, then we'll start with the new questions. Okay, I'm going to go in the order in which you logged into the conference. Columbus, Ohio. Go ahead, please. Columbus, Ohio.
Okay. I had a question regarding the application of the green card for my father. I have a follow-up question.
Hang on 1 second. What is your question number? Ma'am?
I believe it's 4, Reena Iyer.
Reena ji, 1 second. Let me get to that question. I remember the question, of course. No, it's not 4. 1 second. I think it's further down. Yeah, it's 5. Reena, go ahead, please.
5, okay. All right. Thank you for your response, first of all. My follow-up question is regarding the affidavit. If he does not have his wedding certificate, do I need a non-availability of wedding certificate as well?
See, marriage certificates are usually non-available. So I don't think you will need that.
Okay. And I do have one affidavit signed by my uncle.
I saw that.
My question is, do I need 2 affidavits by one person each, or do I need the same affidavit to be signed by 2 people?
Same affidavit can be signed by 2. I mean, basically get 2 affidavits from 2 different people. The language of the affidavits can be the same.
Okay. All right. Thank you so much.
My pleasure. Um, let's get on to the next one. Okay. Tyler, Texas. Go ahead, please.
Hello?
Texas. Go ahead, please.
Yeah. Hi, Rajesh. This is Kumar.
What question number are you, Kumar?
Question number 10.
7 or 10? 10. I
10,
see you.
10.
I see you. Okay, go ahead. Yes, I remember your
Yes,
question.
Rajesh, this is regarding my case one. So basically, my H1 6 years will be getting ended in March 2016. So it's exactly 2 years remaining. So my current employer is planning to apply my firm in June 2014. So almost like 2 months. They have posted the advertisement and everything. So they're planning to apply my firm.
Okay.
But in the meantime, my project got ended, and my current employer has a huge policy of 2 to 3 weeks. So they don't find the project within the 3 weeks, they might terminate the employment. So I'm just thinking whether to stick with this company or leave the company and find a new employer who can handle my GC process smoothly. Because every time if I stick with this employer, in between the projects, I have this tension that they will be terminating my employment.
Um, so the question is, should I go for a more stable job? I guess that's what you're asking me, right, Kumar?
Actually, stable job means I did not get any full-time opportunity till now. Might be I need to go to a small consulting firm. In the past, I had issues with a small consulting firm where I got stuck in India for H1B stamping. So that time I converted to the full-time employee to a big consulting firm
Hang on,
who has a direct
hang on.
line.
Kumar Saab, 1 second. I'm a little confused. What part of this situation would you like me to address? Is it that do I think you have enough time to go somewhere else and start your green card? Or is it, I mean, what exactly do you want me to address? Can you narrow your question down?
Uh, Actually, I just wanted to know, like, if I stick with the same employer and they apply the firm in June 2014 due to bad luck, if my firm gets rejected in 50 year of my H1B, so what are the chances of it, like, can I still
Hang on.
continue with that firm?
Did you listen to my answer to this question? Because I've already answered this question. Did you listen to my answer?
I answered it, but it was very brief, so
Okay.
it was a very brief answer.
Okay, I cannot tell you the details because it's a very long explanation. Okay.
Okay.
I can tell you a couple of things that will help you get some peace. Number one,
Okay.
even if the labor certification perm gets denied, you can file an appeal against the denial. Currently, the appeal times are almost 3.5 years. So, even while the appeal is pending, you can keep getting H1 extensions.
Oh, is it?
Yes. Therefore,
Okay.
you can actually time it and juggle it in such a manner that you start a second green card. In the meantime, you've got your appeal pending. At the right time, you withdraw the appeal and file the new green card, and then further H1 extensions will be based upon that filing. So it can be managed. Don't worry, we've done it a bunch of times.
Oh, okay, cool. So before applying the another, before starting the another GC process, my current employer needs to withdraw that appeal and start the GC process newly.
Please don't try to take notes on this because this is something your lawyers should plan for you. But yes, in general,
Okay,
kind of sort of like that.
okay,
Okay, but like I said, I don't think you ever have to worry because it can be handled
okay.
and
So, Rajesh,
perfectly legally. There's nothing illegal. I'd never do anything illegal.
okay, okay.
Okay.
So in my case, so Rajesh, like if they apply the form like 10 months before my H1B expires, like for 6 years. So I don't have any option. If the case is still pending
Kumar,
also now.
I have addressed all these issues in my response earlier. I'm not going to repeat them. I told you the three options that you have. I'm not going to repeat them. You have any follow-up questions, I can answer them.
Okay, the question is like, I'm just still wondering to stick with the current employer or move to a
I cannot
sponsor.
address that. I cannot address that. That's not a legal question. That's a question about the stability of the company. I don't know. Are they going to be cooperative with your green card? Are they going to take care of things? I don't know. Obviously, this is a long process. You want a company who is both stable as well as cooperative. They care about their employees, they take care of their employees. And of course, they should be doing things by the book. If a company is cutting corners, I don't think you should stick with that company
Okay, all right.
because they can get into trouble anytime. Okay?
Yeah, I know that.
Yep. I deal with this all the time. I mean, things that we could have handled with a couple of $100, now we charge 20,000, 30,000, 40,000 because the company has created so much problem for themselves. So, yeah, just stay away from companies that are breaking the law.
Okay,
Good luck.
okay, all right, thanks. Okay.
You're welcome. Winter Park, Florida. Go ahead, please.
Hey Rajiv, this is Katraj.
Yes, Kartraj.
Good afternoon, Rajiv.
Good afternoon, sir.
This is regarding question number one. Sorry, I might not have mentioned clearly in the question. This is question number one. So neither me or my employer has my old I-140 original document. I lost the original I-140 document. So while filing the 485, will there be any issue? Because
Okay, first of all, hang on. You have a copy of the old I-140?
Oh yes, sir. I have it.
That's all you need. You're not supposed to have the original I-140.
Even with my employer too.
You're not.
He has said
Employer 2 has to, look, Employer 2 is filing your I-140 or are they filing your I-485?
No, employer filed my I-140, but he has sent me the document. I lost that document. He doesn't have it.
Okay, now I'm confused, Katraj. Let's just take a look at it one more time. Hang on one second.
Yes, sir.
Current I-140 was filed by the new employer. You have a copy of the old. Actually, first of all, you don't need ever the original I-140. You only need copies of I-140. You have them?
Okay, either by employer or by...
Doesn't matter. As long as you have copies, you're fine.
Okay. Okay, that was my question was like, even employer...
No, don't worry. This has never been a problem for anything.
Oh. And he didn't request for porting from EB3 to EB2 while he was applying 140. So at the time of 485, even though I don't have my original 140, earlier 140, can I port? Will there be any problem in applying 485 or porting from...
Have you heard my answers?
Yeah, but then my question was not clear to you, so that's why I was like...
No, your question is very clear to me. I'm not changing. Whatever I answered before is exactly the answer now. You don't have to worry about it. It should be done automatically, even if it's not copies enough. Okay?
Sure, sir. And the second question, sir, actually my daughter, can she go at age 2 and come back anytime, like when she's age 10 or age 15?
It doesn't matter. She can be gone for 70 years and come back again. U.S. citizen, once born in the United States, is automatically and forever a U.S. citizen.
No restrictions.
No restrictions. Okay?
And the other question, sir, H1 to H4, do you have any article or any process mentioned in any of your articles or recordings from H1 to H4 process, sir?
Read the instructions on Form I-539.
I-539?
539.
Do you have that on your webpage, sir?
No. It's available on USCIS website. I don't have, it's such a simple process, there is no need for us to have a discussion on how to change status.
Sure, sir. Thanks a lot.
You're welcome. Read up on the instructions, that should be quite clear. Okay?
Sure, sir. Thank you.
You're welcome. Good luck. Okay, let's go to Oklahoma. Britton, Oklahoma.
Rajiv, this is Naveen 256, question number 3.
Okay, Navinji, 1 second. Oh yes, H1, H4. Go ahead, Navinji.
I didn't quite catch the memo that you mentioned.
It's
that
called
talks about coming back to
yeah,
AP.
it's called Cronin.
Sorry?
Cronin. C as in Charlie,
No.
R O N as in Nancy, I N as in Nancy. Cronin. Actually, Cronin memorandum should be on the forums. If you do a search for the word Cronin, it will pull up everything you need to know.
Okay.
Michael, I think his name was Michael Cronin. That guy wrote the memorandum for USCIS. It is still good law.
It's similar to the Neufeld memo.
Well, Neufeld is also a guy. Cronin was also a guy. Bill Yates was also a guy. We call them by the name because it's easier to remember that way. But yes, just like Neufeld memorandum, just like Yates memoranda, Cronin memorandum is a memorandum like that.
Okay, the follow-up question I had on that was, so if she comes back on AP and gets back into H4 upon return, then can she utilize her EAD?
Absolutely.
And then at the time of next renewal, I just apply for H4 and get it renewed.
Absolutely. As long as she's using her, first of all, use of EAD is no problem. Okay. But the moment she starts using her EAD, she is no longer on H4. She's on I-485 pending, which is referred to as authorized period of stay. In order for her to convert back to H4, she has to physically leave the United States and come back on H4 visa.
Oh, so it cannot happen the
Not-
next time
no.
when you knew the H1.
Well, you know what? I'm wrong. No, I'm not wrong. If she had not used the EAD and she came on AP, she could extend her H4 without leaving USA. But if she starts using her EAD, now she has to go outside USA for H4 extension.
Okay.
Which is not a big deal. Don't worry too much. Don't worry too much about it. It's really not that big a deal.
So just to paraphrase, she can come back on AP, stay on H4, but as soon as she starts working on EAD, then the next time during renewal, she cannot get H4 renewed. She'd have to go back to the consulate and...
You know, Naveenji, that's why I like talking to you people so much. You guys are so damn smart. And the answer is yes, absolutely.
Okay, I appreciate that.
My pleasure. Anything else?
Thanks. No, that's it.
Good luck. You know, it's interesting because our immigration work is focused on employment-based, business-based, investment-based issues and complicated issues. So I deal with very, very smart people, and it definitely keeps me humble. All right, let's go to the last posted question, follow-up, which is Arlington, Texas. Go ahead, sir.
Hello, Raj. Yeah. Hi, Rajesh. This is Bhati. Monica has posted questions for me regarding RFP and the client letter.
Oh, yes.
Yeah, first of all, thanks to Monica and you for posting the questions on my behalf.
Absolutely.
Rajiv, I have a couple of questions. You mentioned that the H1B extension will be given only until May 23rd.
Right.
But according to the resolution, the job description and everything, the end date of the project is October 2014. And also,
yeah, hang on. Normally, whatever your evidence shows is the end date of the project, that is what the extension should be given until. So if the project date is October, then you should be able to get H1 extension till October.
But my question is, but the thing is, my company is also providing a manager letter that is stating that even though the project end date is ends like in next few months, but still the contract between the client and our company is renewable. So hence the end date will be 2015 December.
Hang on. Let me understand the situation. Even though the project ends October this year, there is every intention on the part of the client to extend it to 2015, correct?
That is what the manager letter that our company is providing, but client is not.
I cannot predict whether the government will accept that or not. I think it's a chance it could go either way, 50-50. They may accept it, they may not accept it.
But does it not depend on your LCA or RG rather than on the screenshot or on the manager letter?
I don't understand that question. Ask me again.
No, I'm sorry. Does the extension end date depend on the LCA labor condition application?
No. It depends upon
Okay.
your ability to prove how long the project is going to last.
Okay, sir. Thank you. And second question is, do USCIS accept these kind of screenshots as an evidence that this particular person is working, because the screenshots do not show my name on it?
They may or may not. It depends. This is again a question that's like asking a physician to diagnose a patient without looking at the whole patient. If you show me the finger of the patient and say diagnose the patient, I really cannot. One piece of evidence by itself, if by itself without a name, no, it won't be accepted. But if they can prove that it relates to you and your project, then it will be accepted, or it should be accepted.
Yeah, I'm sorry, sir. What is the last part you're cutting off? There's the proof.
I said if they are able to correlate that screenshot with you specifically, then they should be able to accept it.
Okay. And also, even after, let's say, if I get another second RFP, so does it mean that, let's say, for example, if there's a first RFP and my company provides the screenshots, and then the USCIS officer, if he wants to, is it like, can we issue another RFP, or is it going to be a denial if he is not happy with the evidence?
2 RFEs are rare, but not absolutely impossible. So normally it's 1 RFE, but they can always send a second RFE. Yes.
Okay. And my last question, Rajeev, thank you. I have an I-140 approved. Let's say, for example, if I go back to my home country, because the extension has not occurred, it ends on May 18th, for example. So if I go back to the country and and if I come back to the United States after 1 year, do I fall into H1B, fresh H1B cap quota, or
That's a very tricky answer. I can give you my guess, but I cannot tell you there is any specific document I can point to. In my view, you will not be subject to the cap. Okay?
Even though my company applies after, let's say, 2016, they apply after 1.5 year later, and they say that this particular person wants to come back to the United States, so they can even use I-140 and then extend based on that, you are saying.
That is my opinion. You will not be subject to the quota.
Oh, that is good to know. And one other question, I'm sorry, Rajesh, this is the last one, I promise. The thing is, I'm just worried because I know that it's a busy filing season for USCIS. So, I mean, I know you answered 1, 2, and 4, but the third question, would you suggest that I go for regular processing? I mean, I know that there is no rule, but, just like based on your past experience.
I'm sorry, Bhartiji. Your guess is as good as mine. I mean, I do not know. It depends upon how solid the evidence is. If you have a good case, you can go for for premium processing. But if you're doubtful about the strength of your case, then maybe non-premium is better.
Okay, because I have master's degree from US.
It's not the degree. It's the project. Proving the project.
Okay. And then all of the 5 co-workers are getting the RFE. I don't know what's wrong with
Well,
this.
see, I always tell people, when you go to a temple, you get prasadam. मंदिर जाओगे भाई साहब तो प्रसाद तो मिलेगा. So you file a paper with USCIS, you're going to get an RFE 9 cases out of 10. Getting an RFE is not the problem. Getting a denial is the problem.
Because my company, I see. Because my company company is saying that they are just because you guys want to process us in premium processing, and these are busy season. They want to have some more time, so they're just issuing RFP so that they will get more time to review your case. They are saying because they have to. process your case.
I disagree.
Okay.
Okay? Good luck.
Thank you, Rajiv. Appreciate it. Thank you, sir.
You're welcome. Good luck, sir. Okay, guys, anyone has any question, press *5. Any question at all, new, old, doesn't matter. 4. Okay. Now, if you don't raise your hand now, I won't answer any more questions. I've got 4 questions on the table. Those are the ones we'll answer, then we'll call it a day. Please make sure. Okay. 4 questions. Going in the order that you guys logged in, let's start with Michigan.
Hello.
Michigan, go ahead, please.
Hello, my name is Savita, Mr. Raju. How are you?
I'm good, ma'am. How are you?
I'm good, thank you. I have a question regarding change of my status from initial 12-month OPT to H4, while my OPT is still valid. My OPT is valid until June 6th, 2014. So I wanted to change my status from OPT to H4 just now. Like I would like to apply now.
Okay.
So before that, I have a few questions. Is my change of status going to be denied because of unpaid internships that I've been doing till now? Even though my service is updated and I did not cross 3-month period, and even though my OPT is valid and still valid?
Hang on one second. If you go to our website, immigration.com, and you look at some of our sample cases, we have a case in which Nebraska Service Center said, we don't believe that unpaid internships are sufficient to maintain status under OPT. And we wrote back a 30-page brief explaining the law and showing them that they were wrong. So they have backed off of that position. So in my mind, there should not be any issue. Even if you had an unpaid internship, that is good enough.
Okay. So actually my application goes to Vermont Center anyway. So do you think it is not going to be a problem with this center?
I don't think so, ma'am.
Okay. So in case if it is denied, like if I get RFP and if I could not provide enough evidence, if it is denied, so will I be counted out of status from October 7th or from the date of denial?
In my view, if your change of status application gets to the USCIS within the life of your OPT, your out of status period will begin from the date of the denial.
Okay, even though they determine that I am not employed until now, and deny the case, even that case also.
I stand corrected. If they consider you to be out of status, then the out of status is all the way through the OPT period. But that is not a problem. I'll tell you why it's not a problem. Because out of status is not the same thing as unlawful presence. Even if you're out of status, you can get right back into status by converting to H4 or coming back on H1. You just have to leave USA and come back.
Oh, okay. So if my COS is denied and I go to home country to apply for new H4 visa, do you think they're going to deny my new H4 visa based on my out of status period on OPT?
Absolutely not.
Okay. So by giving my overall picture, I think you would better know my situation. My OPT started on July 7, 2013, and my unemployment period ends on October 6th. So you said that I will not be counted from October 7th as out of status, even though they determine that I am unemployed and deny my application. Is that right?
I'm not going to get into that. It's that much calculation is making my head spin. Bottom line is very simple.
Sorry, okay.
No, let me give you the bottom line so that you don't worry. Even if you are out of status the entire 12 months, It is not a ground for denial of an H4 visa.
Oh, sure. Okay.
Okay?
So you're telling me about the H4 visa, but do you think they're going to deny my change of status based on that fact?
If you had an unpaid internship, they should not.
Yeah, I have it, but if I cannot prove it, if they have asked for something, but I could not show them that thing, so in that case, do you think they are going to deny it?
Yes.
Okay. Yeah, I just want to know.
Yeah,
what
if
is
you-
what.
if
Actually, I have
hang
a
on.
letter from the unpaid internship offer letter from the first employer, but I did not have it from the second employer. So I'm in the process of asking them. So I'm just making sure everything will be fine.
Yeah. The way it works is, whatever you cannot prove, it's your job to prove your case. If you cannot prove, you lose the case.
Okay. So in that case also, I may go to the home country and get the H4 without any problems, right?
Yes, ma'am.
And so are they going to ask me about this again when my husband files for I-485?
If you go outside USA and come back, no problem.
Oh, okay. Yeah, I understand that. Okay. So I think I got my answers. But if I want to make an appointment with you, what do I do, Mr. Rajiv?
Look, I'm going to give you the same answers whether you spend money or don't spend money. But if
If I want to
Just- yeah, just-
meet you and ask you to help me with the change of status, like assist me, like
You can-
with payment. So
you can send me an email to help@immigration.com.
okay, sure. Thank
Okay.
you. So what are your timings generally during the weekdays or weekends so that I can call you
You just-
regarding the appointment?
You email me, I'll have my office set up a call for you.
Oh, okay, sure. Thank you very much, Mr. Raju.
You're welcome,
This
ma'am.
is very good. Thank you.
My pleasure. Good luck, ma'am.
Thanks.
Okay, 3 more questions. Let's go to Winter Park, Florida.
Hi Raju, this is Karraj again.
Yes.
Raju, one question is, I am on H1 and I got my I-140 approved.
You're going to have to speak up. I can barely hear you, Katraj. You are on H1, then what?
So, I got my 140 approved.
Okay.
If I want to go back in for 8 months for some personal issues or medical treatment, if my employer doesn't revoke my H1, if the dates are current, can I come back to US on the same H1 and apply the 485 with my employer?
You can, as long as the employer can demonstrate, if asked, that the project that they had for you on H1 is still available.
Oh, or can my employer like file 485 on behalf of me when I'm in India? Is it possible?
485 cannot be filed if you are physically outside the US. But you can convert the case to consular processing. Look, Katraj, I have to take other people. This situation can be a little complicated. So if you don't mind, talk to me again in 2 weeks and narrow your question about only one thing. I want to go to India for 8 months. Can I convert my case to consular processing? I want to address that for you.
Consular processing.
Okay? I'll explain to you how that can be done.
Sure, sir. Thank you.
You're welcome. There is a blocked IP address and phone number. I guess it could be a voice over IP. I don't know who you are or where you are calling from. Talk to me. Say hello.
Hello.
Yes, ma'am. Go ahead.
Yes, this is a question related to 13, question 13.
Uh-huh.
So you said, the question is, have you ever been unlawfully present or overstayed? You said before I-94 expired, if I filed the petition, then you said that it's not considered as overstay or unlawful present, right?
That is correct. Yes, ma'am. Because if you filed your change of status application and it reached USCIS before your current status expired, you are not unlawfully present and you are not out of status.
Okay, but if it is reached to you, it is after...
I'm sorry, I can barely hear you. Speak up. I'm sorry, what did you say?
reached after one day, like today's timing.
Then you've got a problem. You were both unlawfully present and out of status for 177 days.
Okay. So in that case, will it be any problem?
No, no, you should still get your H4 stamping, no problem.
Okay, in that case, do you have to answer yes or no?
I cannot help you fill forms.
Come again?
I cannot help you fill forms.
I'm not getting.
I cannot help you fill forms.
Okay.
But I've already answered your question, and based upon that answer, you can easily fill this form.
Yeah, sure. Thank you.
Okay? Good luck. Okay, last question, guys. North Carolina, go ahead, please.
Rajiv, thank you for providing the, first of all, opportunity to ask this question.
My pleasure.
And my question is like, I have an H1B RFE, like H1B in process, and I have an RFE on that. And in the meantime, I received a better offer, and I applied again with USCIS. Actually, I consulted you a few days back, and based on your answer, I applied again with USCIS.
Okay.
And my question was specific is like, if my latest case gets approved, should I ask my old employer to withdraw the application or
No.
still file the response?
No. Let's look at your case. I need to know a little background. When you applied through your old employer or your current employer that you're working with, was it an H1 extension?
Actually, I am on H4, and it was a change of status from H4 to H1B. So I am not really working right now.
Okay. So basically, you have applied for change of status with two employers. Is that correct?
Yes.
Okay. That makes the situation a little bit, technically a little bit tricky, but I think practically it's not a problem. I'll explain to you why. You see, let's say you've got two cases pending. H4 to H1, H4 to H1 in both cases. If the first case, H4 to H1 is approved, is it appropriate for you to ask for H4 to H1 in the second case because you're already on H1? You see my point?
No. Yeah, I understand.
Okay. So, but as a practical matter, USCIS is not likely to create a big problem about this. I have never known them to be. Okay. If I were you, in the second filing, I would add the fact that currently I'm on H4, but I've got an H4 to H1B transaction request already in another case, just to keep them informed. I personally don't think you have to ask the old employer to withdraw or do anything. The way it works is, let's say I've got H1s going through 5 employers. 1 gets approved, 2 gets approved, 3 gets approved, 4th gets approved, 5th gets approved in that order, time-wise. First gets approved first, 5th get approved last. Just because 1 is approved, 5 does not get nullified. Just because 5 is approved, 1 does not get nullified. They all remain valid.
Okay. My question was like, suppose this latest case, like the second H1 which I filed later after the RFE, and it has high chances of approval. So after that, I should not even try to respond or just leave the first case as it is.
Okay, hang on. That depends. Your H4 is not expired yet, has it?
No. My H4 is not expired yet.
If the H4 is not expired and you have a second H1 with good chance of success, what you do with the first one is more or less irrelevant. You can withdraw it, you can withdraw it, you can leave it the way it is, it doesn't really matter.
Okay. I mean, it will not have any bearing on my second case as such, or will it?
No, don't worry. You should be fine.
Yeah, like basically I was worried that if my first case gets denied after my second case is approved, they are two independent cases, right? I mean, my immigration
yes. Even if the first case gets denied, it will have no impact on approval of the second case, or if already approved, on that approval that is already given. In either case, it's not going to hurt you.
Sure. Thank you, Rajiv.
You're welcome.
I had one question. Yeah, sorry. I just had one question about your services. Suppose like if in my second case also I get an RFE, so I would like wanted to check with you, like with your office, would you be able to take that case?
Look, I will be happy to do it, but you see, here's my problem. I'm not discouraging you from retaining our services. Typically, what happens is when we file an H1, our fees are, I don't remember what our fees are, sorry. They're on our website. If you go to our website and go to About Us, there is our fees. We are one of the few law firms in this country that publishes its fees. Everything we charge is there, okay? But for RFEs, it depends upon how difficult the RFE is to answer. So normally, we'll be happy to. That's not a problem at all. We'll be happy to help you. But be mindful that it depends upon how complicated the RFE is and how much we have to work. Based upon that, we charge.
Sure. Actually, the reason I brought this up question is like, sir, will you be able to prioritize it? I mean, considering my job will be a time constraint. So, I mean, will you be able to prioritize?
Ask me when you come close to that point. I hope we'll be able to take it, because remember, we do not take any more than what we can handle. If we do not have time, we are busy with our existing cases, we'll let you know right away. But if we take the case, then even if we have to stay up 24 hours, we will get it done.
Okay, no problem. Thank you. I'll get in touch with you if that situation arises.
I
Thank you for your time and
I hope you don't have to. I hope your case goes through smoothly.
hope so. Thank you.
You're welcome. All right, guys. Thank you all for being here. I will see you next Thursday. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.